Glad. Thank you.
And then if I may just say on the question of the amicus, I'm not going to address the court in reply. The points made by my learned friend are also points we addressed in our submission in response. So I just asked the court to have a look at our written submission on that, and we stand by that.
We definitely want to,
as the court pleases. Okay, then if I may just start with this point about the so-called separation of powers difficulty. With respect, that submission is very difficult to understand. It's, first of all, wasn't pleaded that way in the founding affidavit, if I may say so, but let's assume for present purposes that that's not an issue. The argument was advanced that the ultimate responsibility lies with social development. You were taken by my learned friend to extensive references in the record to show that the Department of Social Development wanted to increase the value of the grant, was almost frustrated, or in fact was frustrated with Treasury for not being amenable to that increase, critical of Treasury, etc. He made all of those points to then buttress the main submission, which is that social development wants to increase the value of the grant. That is its policy decision, and all they want, and these were his words, he said this expressly, all they want as the respondents is to give effect to social development's policy. But the legislation itself makes clear that the quantum and the details to do with implementation, etc., have to be dealt with in regulations, and they have to be made with the concurrence of the Minister of Finance. That's common cause. Just quickly, the relevant provisions are sections 13 and 32 sub 2 of the Social Assistance Act. So Parliament has decided that not only the quantum, but also the implementation of the payment of this form of social assistance must be done in regulations which have the concurrence of the Minister of Finance. That's what Parliament has decided. And there is no way around confronting the implication of what concurrence means. So there's simply no way to get around the pragmatic and factual reality that the Minister of Finance, if he does not agree with the quantum, has a veto. And it must be like that. That's why Parliament did this deliberately, because it would be nonsensical with respect for social development acting on its own to have the power to decide the value of the grant without the permission of the Treasury or without the buy-in of the Treasury. With respect, it's a very blinkered view of this particular form of social assistance which does not take account the rest of the state's responsibilities. My learned friend almost tried to make that into a virtue by saying, well, you could say the same of any department program. He said, the fact that this is going to cost money and have budgetary implications, you could say the same of any department program. And he tried to imply that, therefore, it's not an excuse, but it's the opposite. The truth of the matter is the question of what to allocate and in what circumstances and in what priority is a classical policy decision. It's an executive-minded policy decision which has to take fiscal considerations into account. Not only does the legislation say that, by making the concurrence of the Minister of Finance compulsory, but as a matter of constitutional logic, it has to be so. Because otherwise, the Department of Social Development could simply set the value at an unaffordable rate. It's just say it shows the logic of what I'm submitting and the illogic of this approach based on the so-called breach of the separation of powers. And just the last point I make on that before I move off this point is that it's dealt with in the papers, this very issue. If I can just give two references, it's paragraphs 30 and 34 of National Treasury's answering affidavit. And that's in volume 4, and at page 742 to 743. Those paragraphs with respect show that all of these points that my learned friend made about the attitude of social development, the desires of social development, the policy choice and goals of social development, with respect, those points are against the respondents. They're not with the respondents. Because if you look at those two paragraphs of the answering affidavit, the court will see that the minister confronts this, the Minister of Finance, my client, confronts this head on, and he says there are differences of opinion within government about the appropriate policy choice to adopt to social assistance. he expressly says in those 2 paragraphs, social development supports a universal basic income grant. And then he goes on to say that that approach is unusual, is the word used, in the international arena. And he says it's a difference of opinion on policy. So with respect, the point is against them because it shows that there is a strident policy debate within government about what the appropriate way to fund social assistance is and what levels of social assistance one needs in the first place. And so that being the case, it goes straight back into the heartland, which the Constitutional Court and this court have repeatedly said is not for the state, for the courts to get into, to decide which line items should be reallocated, which priorities should be at the top of the queue. And in that respect, it's also wrong for them to submit, with respect, that there's no plan, and that Treasury's attitude is that there should be no plan. My learned friend said that on multiple occasions, that the Treasury's position in this court is that number 1, it's unaffordable, and number 2, that not even a plan is necessary to make it affordable. That, with respect, is not true. Treasury repeatedly says in the answering affidavit that it's paying as much as it can afford, but that there is also, in parallel, a series of government interventions which are designed to alleviate the poverty of working age individuals. So it's two-pronged. We're paying as much as we can for now on this grant, but there are also other policy interventions to address the poverty of working age individuals. And just then, now on the question of resources, I just wanted to quickly draw attention to the fact that if one, this court has seen our heads of argument, and I know that I'm under time pressure, but I just ask the court in its own time to just trace the evolution of the socio-economics rights cases, starting from Subramani in 1997, and going all the way to Adonisi, which my learned friend addressed the court on. I will speak about Adonisi in a bit more detail in a moment because my learned friend himself dwelled on it. But if the court follows the train of all the socioeconomic rights cases, what is vitally important to emphasize is there has never been a case where the government relied on a lack of resources, put up evidence to support a lack of resources, and the court nevertheless declared the government's conduct to be unreasonable. Not one. The court will look at each of those decisions and they will see that in all of the decisions that my learned friend relies on, Khoza, Blue Moonlight, Adonisi, and Commando, the court expressly says in their judgment that the state either hasn't relied on a lack of resources as a defense or has not put up evidence of a lack of resources, and therefore there cannot be any acceptance by the court of a lack of resources. If I can just give a brief reference, Khoza, paragraph 50, the court specifically says there that the state has not relied on a lack of resources as a defense. Blue Moonlight, I'll give a reference in a moment, the same thing. The court expressly said there was no evidence put up of a lack of affordability. So the point is that what my learned friends have done is that they cherry pick authorities which are all classical negative rights cases. So where somebody was evicted from a house, for example, and no alternative was made available to them. And they then draw from that conclusions about retrogression in the positive realm where it comes to budgetary constraints. And that is a leap that is not justified if one takes a slow look through each one of the judgments. If one looks at all of the judgments up and through, including a Commando, one will see that retrogression, to the extent that it's relevant, is made part of the general reasonableness inquiry. There is nothing special about it other than that the courts will say, when a measure is truly retrogressive, it has to be the subject of additional scrutiny. But to be retrogressive, it involves, on all of the authorities that you've seen, taking away access that was already there. There is no case in our jurisprudence where a failure to keep up with inflation in a grant that is otherwise giving people more than what they had previously has been treated as retrogressive. And just the last point on that, which I just want to emphasize, can I just ask the court to look at the Mazibuko decision in paragraphs 135 to 137. Because if the court reads those three paragraphs, 135 to 137, the court will see that we are essentially on all fours here. In that decision, there was less overall water supplied to people because there was a change from an estimate basis for billing into a metered basis for billing. So to get rid of all sorts of inefficiencies with accounting, etc., the city decided we're going to give a certain amount, I think it's 6 kiloliters per month free, but we're then going to charge on a new metered basis. The Constitutional Court rejected the argument that because less water was received, the measure was retrogressive. Because the Constitutional Court said, how can we call a measure which is rolling out increased access over time of water in an orderly fashion, how can we call that a retrogressive measure? And it is in those three paragraphs it's expressly dealt with. And we would say with respect that this case is entirely on all fours. We had a situation in 2019 where there was no such thing as this grant. It was brought in as an emergency measure to deal with the effects of COVID, and it's now since then been on a temporary basis increased by 20 Rand. My learned friend said in his oral address how important the 20 Rand increase is. And the minister, and here we would obviously part ways, notwithstanding his submission that the minister throws his hands up and doesn't address these issues properly, the Minister of Finance in his further affidavit in the High Court, from paragraph 13 onwards, that's the one that was filed after the replying affidavit, to respond to the specific issue of the 370 Rand. He spends there in paragraphs 13 to 18 going into detail to explain that no more money was available, but the 20 Rand was found as a reallocation of priorities because of the importance that it has to people. So that cannot be described by any stretch as a retrogressive measure, certainly with reference to the authorities of the Constitutional Court. And I'm mindful of time, I just now want to briefly deal with the question of reasonableness. Oh, sorry, before I do that, sorry, I said I was going to just address Adonisi. Very briefly, I just want to point out to the court. Again, Adonisi was not about the state saying they can't afford something. The question about Adonisi was about reallocation of resources when it comes to where the housing plan must be located. What's important to bear in mind about Adonisi is it's a section 25.5 of the Constitution case. So section 25.5 of the Constitution, which comes in the property clause, not the right to housing. I'm not suggesting that the right to housing was not also considered, but the right to property reads as follows. It says, the state must take reasonable legislative and other measures within its available resources to foster conditions which enable citizens to gain access, and this is an important part, to land on an equitable basis. So in the Constitutional Court, in especially paragraphs 114 to 115 and 167 of Adonisi, the Constitutional Court emphasized that the issue here was, the problem here was, the state had done nothing to address the implications of apartheid, in particular with reference to where people are located within the urban areas. So we know that the pattern in apartheid was that everybody was pushed out to the peripheries. And what the court says here in Adonisi is, here you have a situation where all you are willing to do is to put people on the periphery as part of your housing plan because, and this was also on the evidence, the value of property is too high in the inner city to justify it. That's essentially what the court found. They were saying, well, you wanted to push people to the periphery of the city because the property inside the inner city is too valuable to be wasted on housing plans, etc. So it's totally different. It's got nothing to do with the state saying we literally can't afford to do this. It's got to do with spatial planning and equitable provision of housing in the context of apartheid's history and not wanting to reproduce for the rest of time this imbalance where people are shunted to the periphery. So it's entirely distinguishable. Then lastly, just on this question of reasonableness, the point that I've made is that retrogression is at best relevant to reasonableness. It's not a self-standing test. I've already said that this measure is not retrogressive because it gives more access. So then the question is simply about reasonableness. The first point I just want to make is just on the question of the interpretation of income and social and financial support, and my learned friend saying that it's perverse to take ad hoc assistance into account when it comes to assessing how much a person has in any particular month. Because he said if somebody's been given a donation to help them get out of poverty, it's not fair, or it's perverse in his words, to take that money into account when deciding how much they have access to. But my learned friend for the first and second appellants made the point that this is a month-to-month application. Your means are assessed every month, not every year. So your circumstances can change. And so in 1 month you can be above the threshold, and then in the next month you can go below the threshold. Treasury says in its answering affidavit that that is a reasonable mechanism to try and balance the fact that on the one hand there is insufficient money available to make this grant more widely available, but on the other fact, you're trying to help the most desperate in need. So Treasury says, first of all, you must accept when you're talking about those desperate in need, all grant recipients must be taken into account. And Treasury says that they have taken the reasonable decision to prioritize the other beneficiaries of social grants, because the people who are the beneficiaries of this social grant are at least in principle capable of earning money from work. Children, old age pensioners, disabled people, etc., those people do not have an alternative mechanism to earn a living. And Treasury says in its answering affidavit that the most desperate in need have to be prioritized. But then, within the context of the beneficiaries of this grant in particular, taking people's donations and other short-term income into account is not perverse. On the contrary, it's a mechanism to make sure that the resources can be stretched as far as possible. Because if you don't have that mechanism, the resources won't be there at all. It's to make sure that at least somebody who can afford to the basics, the very, very basics in 1 month, is not as desperately in need as somebody who has literally no other source of income. And I just want to recall the words of Justice Sachs in the Subramani decision. It was a concurring judgment, but it would be well to remember his point where he said, the inescapable fact is that if governments were unable to confer any benefit on any person, unless it conferred an identical benefit on all, the only viable option would be to confer no benefit on anybody. So it's the point we're trying to make is that if you have finite resources, the most desperate in need must be prioritized. Grootboom itself says that. And then within that context, a person who gets a donation of 2,000 Rand is clearly not as desperate as someone who has less than 624 Rand in their monthly earning and therefore qualifies. So that, with respect, we would submit is not perverse. It's in fact, it's a feature of the system which makes it reasonable. Then just on the other issues to do with, for example, the online applications and what my learned friend describes as barriers which are put in place for people to receive it. We have to be very careful, and I'm mindful of time. I'm going to try and make this my last or my second last point, but we have to be careful about a bit of a slippage that can happen when dealing with framing here. My learned friend bends over backwards to say that they're not trying to reallocate the budget, they're not trying to be prescriptive, they only want to plan, they don't want to impose anything on Treasury. But then they also argue that there's 60 million people that are meant to be beneficiaries of this. They describe that as common cause. With respect, it's not common cause, and I'll come back to that in a moment. But they say that it's common cause that there's 16 million people who should be benefiting. And then they say that barriers have been put in place, deliberately so, to prevent people from benefiting. So when I'm talking about slippage, I'm saying that one has to try and follow through the logic of each component of the argument to realize that eventually it becomes unavoidable to say, in the mouths of the respondents, that only an inflation-based social grant that covers all working age people would be acceptable to them. Because the point is that as soon as you say it's unconstitutional, as the High Court said, to have a threshold of 624 Rand, as soon as you say it's unconstitutional, as the High Court said, that the payment is only 370 Rand, and as soon as you say that 16 to 18 million working age people by right have been told that they are entitled to this budget, to this grant, then the implication is that the money has to be found for all 16, 18 million people to be provided for. Treasury and the Department of Social Development frame the matter from the other perspective, which is to say, this is a temporary measure. It is not the same status. It does not have the same status as the other social grants, which have been designed to provide for people who are most in need. And it is a measure where a deliberate choice was made, both by Social Development, and Treasury supports this, to have an over-inclusive approach to preventing fraud, preventing abuse, and preventing and making the system work correctly. So in other words, a deliberate choice was made that there are payoffs between not using online and using online, between making resources available for people to go into the offices and not making them available. The decision was made to create an efficient, fast grant that's immediately available, but which is subject to checks and balances and verification to ensure that there is no abuse. And that is a reasonable mechanism to ensure that the resources are preserved for as long as possible. So, and if I can just give a reference, I don't know what my learned friend for the first and second appellant is going to address, but just to make sure this doesn't slip through the cracks, I just want to refer to two parts of the record to just make this last point. In the department's affidavit, at paragraph 68, at page 1083, and it starts from there but it moves onwards. There's a 68 onwards, starting at page 1083. There is a detailed description about the online application process. And what what the department says there is that it took 15 years for 7 million people to be able to receive children's grants. But it took 6 months for the equivalent, in fact, 1 million more, 8 million people to receive this grant. So if you read those paragraphs, and I accept I accept what Justice Keatley said about the evidence in the department's answer. However, if one reads those paragraphs of the answering affidavit, one will see that the department explains that a choice was made to use a modern online approach, which had the trade-off that it could be rolled out very, very quickly because there was no need for people to come to the offices and submit paperwork and fill out application forms. And they make the point about how proud they are that 8 million people got coverage. So the point is I'm just suggesting with respect that one must be careful about taking one of these things in isolation and saying, well, why couldn't we have in-person applications as well? A human in the loop. If one reads those paragraphs carefully, and they could have gone into more detail, but if one reads those paragraphs carefully, they are saying there is a trade-off that has to be made. And if you put a human in a loop, and you require in-person applications, there is a risk that it's going to prevent the rollout in an orderly, efficient way, and they give the children's grants and the other categories of social grants as an example. And then if I could just refer the court very quickly to paragraph 41 of SASSA's own affidavit, their supporting affidavit. It's paragraph 41 at page 1183. Volume 6, 1183. This is SASSA itself speaking. Justice Keatley asked if there was any justification based on lack of resources. In that paragraph, they don't refer to money, because of course SASSA takes what it's given. It gets given an allocation and it must do its best with it. But what they say is that from a human resources point of view, if we had to accept people in person, it would overwhelm us. We do not have the human capital, we do not have the staff available to be able to deal with applications in person. So just to try and wrap this up and to now finally conclude, and I'm very grateful for the indulgence that I've gone over briefly my 20 minutes. But the point is that our submission is that if one leaves aside the notion that someone can come to the front of the queue, it was Justice Petze's question, and they can find out that they're number 350 in the queue and the money's run out. And so the board comes and it says, now we're closed for business. Let's leave that aside, because nobody is attempting to defend that. My learned friend, Mr. Marcus, pointed out that it's speculative on the papers. That's our argument. Is it speculative on the papers? It's never happened. But if one leaves that aside and one looks at the rest of the measures holistically, the online application, the bank verification, the approach to the fact that if you have a donation in a particular month, you will not qualify because in that particular month you are over the threshold. If you look at that system as a whole, our submission is that it is a reasonable reaction to the very, very, very harsh fiscal condition which has been made out very extensively in the answering affidavit. In a situation where the only way to fund a bigger increase in this grant is with either higher taxation, which Treasury says is not possible, or with borrowing, then one has to have a system which has trade-offs built into it. And Treasury's case is that there are reasonable trade-offs here. Social development's case is that the trade-offs are real, because having it as an online process has actually had a very speedy impact on how people can gain access to it. But we would say in closing that this court would have to conclude that the system as it operates as a whole is unreasonable to the point that it must be set aside, and then we'll have to decide what order it makes. And that's where the problem with the High Court's order comes in, which is to say that my learned friend is wrong when he says it's not prescriptive. Because if one looks at paragraphs 14 and 15, they set aside as unconstitutional the value of the grant and the value of the threshold. And then in paragraph 17, there's an order about the plan, and if one reads those items that have to be taken into account, it's impossible to say that it would be a lawful decision not to increase based on inflation.
That's the conclusion.
Yes. And so we would say, once one accepts that you can't rejigger the budget in that way, then we say this is a plan with lots of trade-offs, but it's a reasonable plan, which on the jurisprudence of the socio-economic rights can't be set aside. As the court presumes.
Thank you, Mr. Stevens.
Thank you, Justices. I only want to address two issues. The first is the Rule 11 application. There is an application for what is termed the preemption affidavit to be admitted. We oppose that application. We put in heads of argument and we stand by those heads. If the court is against us on that issue, we will, like Treasury, also ask for time. We will fit in with the timelines if the budget speech is admitted as new evidence and timelines are given to Treasury, then we'll fit in with those timelines. But we...
We're not saying we're against anybody at this stage. We're saying that if that point needs to be ventilated, then everybody needs an opportunity to file their papers so that we get the full picture when we make a determination.
Yes. So we stand with our heads of argument on that point.
And you also need time to file.
And we'll also need time to file. The second issue concerns the submission that there is approximately 1 million appeals a month, and the contention that there should be a mechanism to place new evidence in respect of those appeals before the appeal tribunal. We've made our submissions about administrative paralysis, and I'm not going to repeat those. But the SRD system is not built to accommodate documentation. If 1 million documents a month must be processed by SASSA, the system will break down. The system is not designed to take physical documents. It will have to be redesigned. In the interim, 8 million beneficiaries are paid on a monthly basis. So we ask the court to take that into account. when dealing with that issue. Those are my submissions.
Thank you, so much.
Yeah, but now he's saying that it's going to take 6 weeks.
Immediate remarks.
Would you see what's that?
No, we can tell them, they can tell their client that, you know, those judges in Bloemfontein are difficult. This is the length of time they've given us. So we have, yeah.
Marcus?
I suspect I know what you're going to say.
Yes. Because if you don't agree, then I'm going to dictate.
Yes.
And that will be, I don't think you guys will like that.
So is there some sort of agreement that can be reached? Or else we'll then dictate through the registrar that this is the date that we want the affidavits to be filed. And this is the date when the reply will be done.
Can I suggest that really, and I'm not exaggerating here, not less than 3 weeks? Justice Mayor, I've given you some indication in my main address of what the budget entails by reference to Section 27 of the PFMA. We're going to have to explain that now in relation to the budget speech. If you tell us 2 weeks, we always accept what the court tells us. I'm asking for 3.
You're just fortunate because
It would seem that this half agrees that 3 weeks will be sufficient.
Okay, okay, well, okay, then I'll settle on 3.
And I got the casting votes quite correctly. So it will be 3 weeks to file, both the appealants to file, and thereafter you would have, Mr. Pickle,
1 week.
you'll have a week. No, you can't have 2 weeks.
Yeah.
You'll have a week to reply. Right.
You want to be generous, at least give them 7 court days to respondents. Instead of a week.
Circumstances, judgment is reserved after we've received the
affidavits from the appearance in 2 weeks' time, and after we receive the reply a week thereafter from the respondents. Judgment is reserved, and thank you very much for
supplying us with the heads of arguments and make life simpler in these circumstances. And all that I need to say is that everybody travel safely back to their respective workplaces. Let's adjourn. Court will rise.